Welcome to Looking at Legal Stuff. Today we have 5 hearings in a case with a couple where Mama's motioning the court for adequate cause to change the parenting plan after an incident in the middle of the night where Dad was drunk and sending her inappropriate text messages about their son. Due to this incident, as well as other past incidents of drinking and DV, Mom was given a protective order that still allowed them to communicate for their son's sake, but Dad has refused to speak to or see their son for 4 months now and claims that he's unwilling to risk getting arrested to contact her for any reason. Mom wants to change the parenting plan from the week-on, week-off 50-50 custody that they had been doing before the protective order to some sort of supervised visitation. What does Dad have to say about Mom's claims? Let's find out.
Thank you.
Mackenzie Goebel and Ian Goebel.
I'm here, Your Honor.
I'm here.
And we have Ms. Height. And so folks, I'm looking at a set of paperwork. Includes the findings and conclusions, decree of dissolution, parenting plan. Are you all agreed on this? Is
Yes.
that correct, Mr. Goebel?
Yes. Yes.
And Ms. Height, you're comfortable with the parenting plan?
Yes, Your Honor.
All right. We also have the testimony by affidavit. So I'll sign the order dismissing the GAL. And Mr. and Ms. Goebel, if you'd each raise your right hand, please. Do you swear to tell the truth in this proceeding?
Yes.
All right, and let's see, ma'am, you were married in 2012. Is that right?
Yeah.
And separated in July of 2021.
Correct.
And you split all your property, all your debts.
Yes.
And is the parenting plan that's being proposed the one that you have been using?
Yes.
And that's working for you?
Yes, it is.
And you're comfortable with the child support order?
I am. Yeah.
And Mr. Goebel, is all that correct?
Yes, it is.
All right, folks, I note that your parenting plan is a week on, week off. I know people who have grown up in those parenting plans. They can be real tough if the parents aren't cooperating with each other because the kids kind of feel like they're living out of a laundry basket. So it just makes it real imperative that you guys work together for the sake of your child. I'm sure you understand that, right?
We do. Yeah.
Okay, good.
Yes.
All right, I will sign the decree, parenting plan, child support order. Thank you very much.
Thank you.
Thank you.
Next, I have Mackenzie Goebel and Ian Goebel, 213-35508 is the cause number. Mackenzie Goebel, are you on the line today?
Yes.
Okay, welcome to you. And Ian Goebel, are you on the line?
Yes, Your Honor.
Okay, welcome to you, Mr. Goebel. All right, this is Ms. Goebel's motion for adequate cause to modify a parenting plan. It looks like I saw service occurred on June 4th. And I was just checking with Mr. Goebel. I know what Ms. Goebel's position on the issues are. She submitted documents and I see that. And there's some a flavor of maybe what your response was, but from some text messages that were submitted by Ms. Goebel, but I didn't receive anything in particular or specific from you. Did you file anything in response to her motion?
I did not. I have been extremely busy with work and I haven't had a chance to complete any paperwork.
Okay. And so what was your anticipation in coming to court today?
Well, we had a court date set, so I figured I should probably be here.
Okay. And is it your plan to submit something or not submit paperwork related to your position?
Will I be able to speak on the paperwork that's already been submitted, or do I need to submit anything to be able to talk?
So the difficulty that's encountered is that at this point, Ms. Goebel, she's kind of laid her cards out on the table, right? You know what she's wanting and her rationale and her thoughts. And if you were to come in today, you could say whatever you wanted to say. But number one, it's not under penalty of perjury, the statement. So that's missing. And number two, Ms. Goebel has not had an opportunity to review in preparation for review your statements or your position in preparation for today's hearing. So it kind of puts her at a disadvantage of not knowing what you are going to say because you know exactly what she's going to say because she's already filed it all. So that's, as a general rule, that's why I generally shy away from allowing people to provide oral input at a hearing or verbal input at a hearing because number one, its statements are not made under the penalty of perjury, and number two, it's kind of springs new information on one of the parties, and it strikes me as not being fair.
I understand, Your Honor.
So Ms. Goebel has taken time away from her schedule, as have you. So if we do set it over to a different date, can you assure me that if you want to respond, that you would be submitting something in writing and serving her a copy?
Yes, I can, Your Honor.
Okay. Ms. Goebel, let me just touch base with you as far as with your motion. You kind of heard my explanation. That I like to hear from both sides of the equation to get a full picture of what's happening. Do you have any concerns if we were to set this matter over? It would probably be a 2-week set over, which would put us at the July 10th timeframe. Do you have any concerns if that were to occur?
The only concerns that I have is of right now, we do have 50-50 and he could ask for our child. And I don't think that's the safest option for our child. So is there a temporary documentation that we can sign to put our child in my care until the next court date?
Yeah, and your concerns stem from the alcohol consumption and driving and
Correct. And there's been 2 CPS reports put in, one from the school counselor, one from my son's therapist, both pretty much stating the same exact report. Also, I'm a visit supervisor, and I also did my own report. And between me and my significant other, who at the time was also a visit supervisor, and all of our reports all match. I know I've been in contact with the CPS social worker, and she went ahead. I'm not certain that they completely dropped the case, but I know that it's not a rushed case due to the fact that Ian is, our son Ian is in placement with me. He's not needing to be in a different placement. I don't know if the investigation is still ongoing.
Can you remind me the age of Ian? Or
He
a
is 10
child?
10 years old.
10. Okay, 10. So your request today, and kind of an emergent basis, is for the child to be in your custody until the hearing.
Correct.
Okay. Mr. Goebel, do you have a position on that?
No, Your Honor, not at this time.
Okay. I'm going to award temporary immediate custody of the child from now until the hearing date. The child be in the custody of Ms. Goebel. I'll just draft a brief order to that effect. All issues will be addressed at the next hearing related to the motion. So let me just draft that and then I'll read it to you so you know what it says. So the order is: the minor child shall be in the custody of petitioner Mackenzie M. Goebel beginning today and extending until the hearing set for July 10th is completed. So that will allow Mr. Goebel to submit his declaration and information that he wants the court to review. And so his voice is heard, and that'll keep the child in Ms. Goebel's care until that hearing is completed. And then on that hearing, we'll take up the motion for adequate cause and the motion to modify the parenting plan. Any questions, Ms. Goebel or Mr. Goebel?
I do. So since this is getting pushed back, I wanted to update because now we're at the end of June, and if you looked at Exhibit F, I have all the calendars since Mr. Goebel pretty much abandoned his child, and it only goes until May. And I would like to add June in there since we're at the end of June now. Is this something that I can submit? And there's a couple other sealed confidential documents that I would like to add in from his therapist.
You can
And
supplement your position with any filings you'd like, and you can send copies to Mr. Goebel.
Perfect.
Mr. Goebel, do you have any questions?
No, Your Honor.
Okay, we'll see you on July 10th then. Thank you.
Thank you.
Next, I have Mackenzie Goebel and Ian Goebel, 213355-08. Mackenzie Goebel, are you here today, Mackenzie?
Yes, I am.
Okay, welcome to you, Ms. Goebel. And then Ian Goebel, are you on the line today?
Yes, I am.
Okay, welcome to you, sir. Okay, this is a motion brought by Ms. Goebel for adequate cause to modify a parenting plan, and then a motion to modify a parenting plan. In looking over the case, I've taken notes on this, and it looks like the most recent order was from October of 2023. Looks like there was an issue related to a criminal matter with this involving domestic violence, and then maybe a concern related to CPS brought to the attention of CPS regarding drinking and driving. So I've read the pleas submitted by both parties, so I'll hear from you first, Ms. Goebel, and then from you, Mr. Goebel.
Good morning. So yeah, we were sharing 50-50 of our son Ian, and it was February 2nd that I received inappropriate text messages from Mr. Goebel, who was intoxicated. There was a lot of messages sent that night. I couldn't provide all of them, as I don't think the courts have time to review all the text messages that were sent that night. But if you look at Exhibit C, I did attach quite a couple text messages that he had sent me, stating that our son is too hard to handle for him, and that he would be okay to give Ian up to me if I took him back to court. He referred to our son as an effer. Not comfortable saying the word in court. However, he also gave Ian up to me on February 4th, which was his parenting week. His parenting week was February 2nd, and he came and he picked Ian up late. And then when I got Ian on February 4th, Ian's cell phone was broke, and we questioned Ian on why his cell phone was broken. We being me and my partner that I am with currently, he told us that his dad was intoxicated when he picked him up and drove him home. He explained the whole scenario of the route that his father took. I went and he showed me where his father drove off road, and there was tire tracks that matched the tread on the car that he was driving. And so I called as a visitation supervisor and mandated reporter. I was to make a CPS report, but I did contact the school counselor and told her what Ian had told me about the incident that had happened that night. Her being a mandated reporter, she also reported to CPS. Within 2 hours, a social worker had arrived at the school to start an investigation on questioning Ian on what had happened. And I got him enrolled in counseling. And during the first session of counseling, that therapist also per her mandated reporter, had to report to CPS as well. There were some other concerning things that Ian had brought to the counselor's attention and to my attention. If you look at Exhibit D, that is a report that we had typed up of the incident that Ian told us happened that night. So that one I sent to the social worker at CPS as well. Following that, Mr. Goebel has not had any contact. His last parenting day, if you look at Exhibit F, the last time had Ian on the 17th. He stated in his report
17th of
March. Yeah, the 17th of March. He has only had one phone call with Ian that was 8 minutes long on April 2nd. That is the only time. And he was told that his son was trying to get a hold of him. His son has reached out and the phone goes to voicemail. One of the weekends, his son reached out. I believe it was something about baseball. His son has reached out and Mr. Goebel was in jail. We looked at the jail roster. He had on February 13th, he had court. And that's when the protection order between him and I was set in place. So he has not had any contact with me since the 13th, even though the protection order does state that there is a exception in there that he can communicate with me for the sake of our son. He has yet to make any communication. I've reached out to him with baseball schedules. I was letting him know his son was pitching in his first game, and there was nothing with him showing up to any games. He makes the excuse that he is scared to reach out because he's fearful that I will manipulate the narrative. I think it's important and I encourage him to keep going to counseling. I noticed he stated in his report that he is seeking therapy and he has been diagnosed with PTSD. However, I do not think it is appropriate for Ian to be in Mr. Goebel's care full time and suffering consequences of his PTSD while he's in treatment. I think, my concern is Ian feeling uncomfortable after the length of absence of Mr. Goebel. I did find he's got a tablet that he plays on, and I did find in there that he's been searching up, his dad, and, he's curious about his dad still. And I encourage him that he still reaches out to try to have some kind of relationship with his father. But as in having visitations without being supervised, I think is unsafe for the circumstances right now with his absence that he's created with no contact. So I still do have Ian currently enrolled in counseling at Columbia Wellness, and I know Mr. Goebel does not have a valid driver's license and insurance, and he is still out driving around. I fear that he will drive our son around. I was made aware of his DUI that he got after my son came to me and told me that his dad was drunk while driving. I did call the prosecuting attorney and let him know the incident that had happened. And also with that, I was aware that he had a DUI that he had gotten in Wahkiakum County in October of 2022. And
So
he
that's
had been
that's the only DUI conviction is from the Wahkiakum County matter in October 2022.
Correct. Yeah, that was the only DUI incident was then. But yeah, I was made aware of that after the incident on February when I got Ian on February 4th, and I contacted the prosecuting attorney, and that's when I had found out that he has a DUI and he lost his license, and he's been driving our son around with no valid driver's license. So that I put in the parenting plan that he is not to operate a motor vehicle unless he shows proof of a valid driver's license. And I'm also asking that the court take in consideration that Ian has not seen his dad since March 17th. And he has only made contact with Ian one time. And mind you, with the last date of being seen on March 17th, he's only had Ian since he gave him up to me on February 4th on his week. He's only had Ian overnight, and one of those overnights we tried reaching out to him on a Friday to meet up with a friend to take Ian out to his location. And he refused to answer the phone. He stated to my brother next day when we reached contact, he stated to my brother that he had fallen asleep. And to me, that's, you know, there could be multiple excuses to not see your son, but none of his excuses are valid to me on why he's not present in his son's life. His son loves him very much. They did have a great relationship. Mr. Goebel was always a great dad. So since February, I don't know what's been going on, but he has been absent.
Okay.
But
Right.
other than that, I think that's it. I know our son is just scared to see his dad.
Okay. All right, thank you. Just one clarifying question, if I may, Ms. Goebel. In your documents that you alluded to that Mr. Goebel was sentenced to a criminal matter in 2024? Or is that just that he's on probation through the Wahkiakum DUI?
So he did get the DUI in Wahkiakum County. He was also on February 13th when he went to court, which is the protection order that was set into place. There was a domestic violence incident that was between Mr. Goebel and I when we were still together. That led to our divorce with an anger outburst and with his use of alcohol. He held me down, pinned me down to the ground. And
so I'm curious, in 2024, was there a criminal conviction on Mr. Goebel?
Yes, for domestic violence.
For violation of a no contact order, or for an actual incident involving physical contact?
He was charged with domestic violence on February 13th.
So
he was
assault in the fourth degree.
Yeah, that might have, yeah.
Okay, and that case resulted in a conviction?
I believe so. I know he was court ordered to do hours of community service, and instead he exchanged for, I think that was the jail time that he served.
Okay, and that was for an assault that occurred on February 13th?
That was an assault that occurred from December of, I want to say 2021 is when the domestic violence incident happened, but he didn't follow the court order, and so they charged him with it on February 13th of 2024.
Okay, so it's kind of like a stipulated continuance or a deferred prosecution or something of that nature.
Yeah, because they weren't going to put the domestic violence on his record or the assault on his record if he followed the court orders that he was supposed to do. And from my understanding, he didn't follow those court orders. He said that he refuses to go to therapy and get the help that he needs. And so they decided to charge him. And then because of the text messages that he had sent me, stating that I have what's coming to me, then I did ask the prosecuting attorney on that day to please put a protection order between Mr. Goebel and I for a year.
Okay, and was that order entered?
It was, yeah.
Okay, all right. Okay, Ms. Goebel, thank you. We'll hear from Mr. Goebel. Mr. Goebel?
Yes, Your Honor. So I understand, I didn't necessarily make the best decisions that night. That kind of have led me to where we're at right now. And I'm not disagreeing with what she wants to change in the parenting plan, but I noticed in the parenting plan that there was no progression of it ever not being, non-supervised. So that's why I put in my parenting plan to have it be a little bit more progressive. Start out with supervised visitation with a professional or otherwise agreed upon third party, and then maybe progress to just doing one day, maybe no overnights for a little while, and then just work into weekends again. I would never intentionally put my son in danger. The night in question, I was not intoxicated. Yes, I should not have been driving that night because of my suspended license. However, I was not under the influence of alcohol. And the other night that Miss Goebel had brought up was the one where she had mentioned that I fell asleep, and yes, I did fall asleep. I had talked to the person doing the pickup and drop off, and they had stated that it was going to be pretty late at night, and it was almost 10 o'clock at night is when she said that they were going to be dropping Ian off. So, I mean, I did fall asleep. It was a Friday night. I worked all day. And as far as not communicating with him, it is true. I am worried that Miss Goebel would skew what was actually said and use it against me. And that's the reason I never went to any of his baseball games as much as I wanted to go. I watched all last season. I love watching him play, but the restraining order says I can't be within 1,000 feet of her. And there's nowhere in that baseball field that I could see him play and still be 1,000 feet away from her. And whether she's the one that calls or somebody else calls, I don't want to risk getting in trouble for it.
How long is that no contact order valid?
Your Honor, it's valid for a year.
It's 1 year, so it'll expire in February 2025.
Yes, sir, it will.
Okay, all right, thank you.
Ms. Goebel and I also had a verbal agreement that I was going to let her take Ian for a little while I paid off some debt and got moved into a little bit better of a living situation, which I have gotten moved into a better living situation. And been working on paying off debt, which was the original agreement that we had, and things obviously have kind of spiraled for the worst since then.
Any other input you want me to know or be aware of, Mr. Goebel?
Not off the top of my head, Your Honor.
Okay, all right. Thank you. So there's a request by Ms. Goebel for you to get an SUD or a substance use disorder evaluation, and if they recommend treatment, then do treatment. She's also recommending a mental health evaluation and if applicable, a treatment. Do you have any position on those requests?
I mean, as far as drugs and alcohol treatment goes, I went through the treatment for my DUI already.
When you say you went through it already, when did you complete the treatment?
I completed it after I was convicted of it, so somewhere around probably April of 2023.
Okay. Okay. And then as far as the mental health evaluation, do you have any input on that?
I don't have a problem with that at all.
Okay. All right. And then as far as the status of your driver's license, do you have any concerns if there would be a restriction that said that you wouldn't be able to transport child until you have a valid driver's license and proof of insurance?
Yeah, I won't transport him until I do, and that's why we need to find a reliable third party to help out with that until I can get that taken care of.
Okay, all right. And then do you know, do you have any information related to any status updates of the CPS complaints? If you've received any contact from them, if you've received any founded, unfounded letters?
So I have not received anything from them. Well, no, that's not true. I only know about one of them, and as far as I was concerned, I was under the impression that it was getting closed. And this was March of 24. Amy Farley is the one that took care of it. She got a hold of me and we talked about it and said there was no reason to further pursue this case. So last time we were in court on the 26th of June is when I found out that there was 3. I had no knowledge of them.
Okay. And then, so no formal correspondence from CPS related to any status updates or closure or continuation or founded, unfounded?
No, sir.
Okay. All right. Okay. Anything else, Mr. Goebel?
No, sir.
Okay. All right. Thank you. Ms. Goebel, I'll give you just a brief moment for any reply.
Okay. So I did he said that there wasn't any limitations for the supervised visits. I did put limitation on supervised visits, until the CPS investigation is complete and Mr. Goebel's mental health evaluation, until he has one, and a substance abuse evaluation, whether that, is a hair follicle. However, I am willing to finance the drug test, the substance abuse. I'm willing to finance that as long as it does come back negative. If it comes back positive, I would like Mr. Goebel to reimburse for the drug test. I know he mentioned Ian being dropped off late was due to a baseball game, and he was aware that he was going to be dropped off late for that. There is an exception stating in the protection order that he is allowed to communicate with me for the sake of the child. He is allowed to call my phone to talk to his child. I have never told him he could not. He also that when he did call Ian for the 8 minutes on March, what was it, April 2nd or something like that? I think it was April 2nd. He did contact my significant other's cell phone to talk to Ian. So he has had that option this whole time. But it does sound like, he is agreeing to supervised visits, but I did put limitations in there that it will be lifted once I do receive, the things that I had asked for. And then I also asked that visits take place on the first, third, and fifth Saturday from 12 to 6, supervised or unsupervised, for those until our child feels comfortable enough regaining that relationship with his dad. I've been currently working with support enforcement for child support. I don't know how far back I can backdate for child support. But that is something that I am asking take place, is that he does pay child support and maybe backdate. Since I've had Ian since February, I'd like it to be backdated since February, but March if possible.
So Ms. Goebel, just on that last point, as far as child support, there's not a pending motion that I saw related to child support. So the oral motion today, I'm not going to entertain it. If that's something that you're seeking, then you'd need to file a motion or work through the administrative channels of child support.
Okay.
Okay, okay, thanks to the parties. I appreciate that. So, oh, one last question, Ms. Goble. As far as the no contact order, you mentioned there's a carve-out exception for communication with the child that allows Mr. Goble to communicate with you regarding the child. And is there also a 1,000-foot restriction in that no contact order?
Yes, exception of the child. So if I know we do our child swaps or per the paperwork at the police department, however, with him not having a license, we haven't been able to do that. So there is the 1,000 feet. However, there's an exception with our child. So baseball games run in that exception because it has to do with our child.
Do you have a cause number for that case?
For the protection order,
Mhm.
I
Yes.
don't. I actually don't even have the protection order in front of me.
Mr. Goble, do you by chance know the cause number?
No, sir, I do not.
So there's a 1,000-foot geographic restriction that prohibits Mr. Goble from being within 1,000 feet of Ms. Goble. And do you recall, Mr. Goble, is there a specific language as far as an exception that says that there's an exception that you can be in a closer proximity if you're watching a baseball game or something maybe more general than that?
The only exception that I am aware of is the communication that we could have between the two of us. But I don't remember them saying anything about space. How did you put that? The geographical location to each other.
Yeah, okay. And Ms. Goble, you don't have a copy of that order?
Not on me in front of me. I know I do somewhere. It might be down in my filing cabinet with all the other paperwork that I have.
Okay, all right. Thanks. Okay, so I'm going to make a finding of adequate cause. I think there's adequate cause to modify the parenting plan. I think it was best summarized by Ms. Goble that there's been a big change in dad or Mr. Goble. He said it indicates that he's a great dad, and then there's been a rough patch here, and that he's been absent. And there's been issues with the alcohol. There's been some concerns related to that, and also it looks like a kind of a revocation from maybe a stipulated continuance type case in February of this year related to an incident back in December of 2021. So I'll make a finding of adequate cause. Then moving forward, I think modification of the parenting plan, at least for a period of time, I think is appropriate. So there's been a period of time, and not knowing the specifics of that no contact order, it sounds like, if there is that 1,000-foot geographic restriction, I can understand why Mr. Goble wouldn't want to go to a baseball game. I mean, he'd want to go to the baseball game of his child, but if there's a chance that he's going to get arrested, then he's going to err on the side of caution and not go. I can see where a person would make that decision, and that would be kind of an excruciating decision because you certainly want to see your child play baseball and let them know you're supporting them and the like. But if there's that restriction there and there's a potential of being arrested, and then I can see why a person may not do that. There is an exception for communication with the child, and maybe that's been a bit lacking. But then there may be some concerns related to that about getting in trouble if it's interpreted in a different way than it was intended. Nonetheless, there's been an absence there between child and father. The child's 10, I believe. So I think that we'll modify the parenting plan in the following manner. That is related to the first and third and fifth Saturdays of each month. There'll be visitations with Mr. Goble and Ian on a supervised basis. It can be a lay person, just agreed between the parties. Doesn't have to be a professional. And it'll be supervised until Mr. Goble completes a mental health evaluation and commences, if applicable, any recommended treatment. Same for a substance use disorder evaluation. I recognize Mr. Goble indicated that he completed that in April of 2023. There's an indication here that there was some alcohol consumption and alleged driving while intoxicated or after drinking with the child in February, I believe. So just to err on the side of caution, I'm going to require that SUD evaluation be completed with collateral input from Ms. Goebel. And if that evaluation says then treatment's necessary, then Mr. Goebel would need to begin or commence that treatment. So it'll be supervised up until that time. So once those conditions have been met, that the mental health evaluation has been completed, the SUD evaluation has been completed, and any recommended treatment has been commenced, then it can go to unsupervised that same period, the first, third, fifth Saturdays from noon to 6. At any point, Ms. Goebel can request a hair follicle test, and that hair follicle test would have to be submitted to within 4 hours. And she would have to prepay for it. And if it comes back that it's clean, then she just eats that cost. If it comes back with any substances, then Mr. Goebel would need to reimburse her for that cost of that testing. So once the unsupervised visitation is ongoing, that'll be for a period of 2 months. So once the 2-month period has ended, then we'll, after the 2 months, then it will go to that same first, third, and fifth weekends from Friday after school or 5 p.m. if it's not school, until Sunday at 5 p.m. And that would be a period of 6 months. And then after the completion of that 6 month after the visits, and there's a continued compliance with any recommended treatment of mental health or SUD, then it can revert back to the 50-50 plan. But before we do that, I want to have a review hearing. But that's kind of where the court's thinking. I think that there was something pretty dramatic had happened. Then there'll be this period of coming together again and getting back in the groove, if you will, and making sure that everything's okay with Mr. Goebel and that the child is safe and well. And then after that completion of the weekend visits for 6 months, then a motion would need to be brought for a review / a motion to expand back to the 50-50. So with the driver's license, the transportation of the child, Mr. Goebel would be restricted or prohibited from doing that until he has a valid driver's license and proof of insurance. In between, I think joint decision-making is still important. And so I'm going to order the joint decision-making related to medical and educational and extracurricular be joint. And that's allowed in the no contact order based on the communication regarding the child. So that's the court's order. I'll ask Ms. Goebel, since you are the moving party, I received an adequate cause order and I've signed off on that. I didn't see a proposed parenting plan that matches with what I ruled here today. So I'd ask that you prepare that, and then mirroring the court's ruling today, and then provide a copy to Mr. Goebel, and we'll set it for review on the 24th of July at 9 o'clock in the morning to make sure that proposed order captures what the court ordered here today.
Okay, so I need to put together a parenting plan with what you just talked about and went over. Serve Mr. Goebel with it, the court, and then we'll revisit the parenting plan on the 24th and have it signed off. Is that?
Yeah, basically that's what it is. The presentation is to sign off on that proposed order that memorializes the court's decision today.
Okay. And I heard you mention something for two months you said would be supervised visits. If he does what he needs to, the next 6 months will be limited visits to the first, third, fifth Saturday, and then open to going to 50-50 after the 6 months.
Correct. So it starts out the noon to 6. It'll be supervised until the mental health evaluation and the SUD evaluation have completed and he's begun treatment if recommended. So then once he's completed those, and if treatment is recommended and he started that, then it can move to unsupervised. So there's not a time frame on that. And then once he's completed that, And then that would be for that period of time that you mentioned, and then the 6-month period.
Okay, and I know he's, oh, excuse me. I know he has been hesitant to contact me. I'm curious how because our son doesn't have a phone still. He hasn't given his cell phone back. It's also broken. I know he stated in his response that he's willing to provide Ian with a cell phone. I'm actually looking forward to getting Ian a new cell phone and getting him back on our cell phone plan. However, if he's wanting visitations to happen, I need some kind of communication from Mr. Goebel that he's comfortable with.
So if the no contact order says that the parents can communicate regarding the child, then Mr. Goebel's free to contact you and communicate with the child. And if either party wants to get the child a phone, either party can get the child a phone, and there can be communication through those means also.
Okay.
So any questions on your end, Mr. Goebel?
Just so we're clear, I can contact her regarding Ian, and I don't have to worry about any kind of repercussions.
So I'll just give this just with a bit of a caveat. I haven't reviewed the order. I haven't been given a copy. No party's read it to me here today. I'm working on the assumption that there's a no contact order that allows for an exception that allows parents to communicate regarding the child. And if that's the case, then the parties can communicate regarding the child. If there's any concerns related to what that order does or doesn't say, I would suggest contacting legal counsel to review that and advise you as to the scope or the breadth of it.
Okay.
Okay, so Ms. Goebel, any final questions?
For the supervised visits, because it can be third party. You said it has to be, so I have to agree on who he can use for supervised visits, right?
Yeah, it cannot be unreasonably denied. So there has to be
Okay.
agreed supervisor, and that agreement cannot be unreasonably denied.
Okay.
Okay, any other questions?
No, that's it.
Okay, so we'll see everybody on July 24th at 9 o'clock. If the parties agree that with the order that's presented or prepared by Ms. Goebel, if she got it right, in other words, she summarized what the court ordered here today, then neither party would need to be here on the 24th. You could both just simply sign off on the order and present it to the court for signature. However, if there's any disagreement or question, then I'd expect to see both of you here with that proposed order.
Okay.
Okay, that'll conclude the hearing today. Thank you.
Thank you.
Goebel and Goebel.
I'm here, Your Honor.
Good morning. Is Ian Goebel present?
Yes, I'm here, Your Honor.
All right. So this is a matter was heard by Judge. I don't know if you folks have an agreed order here.
I am looking at getting that set over a little further. It's not quite done yet.
Okay.
The gal that is helping me had a family emergency, so she was unable to complete the parenting plan.
Okay. So how much time do you think you need?
Can we push it out another 2 weeks?
2 weeks? Okay, I think that should work. So we'll put that over to the 7th of August at 9 a.m. And then Evans will be here if there's any issues on the language.
Thank you.
Okay.
Next matter I have, we'll hear, please, is Mackenzie Goebel and Ian Goebel, cause number 213-35508. Mackenzie Goebel, are you on the line today?
I am.
Okay, welcome to you, Ms. Goebel.
Thank you.
And then Ian Goebel, are you on the line?
Yes, I am.
All right, great. Welcome to you, Mr. Goebel. All right, we're on today for, it looks like a presentation. There was a oral ruling on July 10th of 2024. Indication was that Ms. Goebel was going to be drafting that order, and let me double check with Ms. Goebel. Did you submit a proposed draft of that order?
I did, with a few changes that we do agree on.
Did you submit it to the court?
Yes.
Okay. All right, so this was handed to me just during the middle of the docket, so I haven't reviewed it. Mr. Goebel, did you get a copy of that proposed order?
Yes, Your Honor, I did.
And do you feel that it accurately reflects what the court ordered on July 10th?
It does, but like Ms. Goebel said, there are a couple of changes that we had talked about and agree on in there.
Okay, all right, and so you've reviewed those changes and you feel comfortable with those and you agree on those?
Yes, I have.
Do you feel like you're being pressured into agreeing to those changes?
No, I'm not.
Okay, and you're making that of your full volition and freedom and choice?
Yes, sir, I am.
Okay. So so I have that here. Let me just take a quick look over at things. Okay. I've looked over that. I'm fine with that. Do both parties feel comfortable if I were to sign off on that parenting plan?
Yes, Your Honor.
Mr. Goebel?
Yes, Your Honor.
All right, very good. I'll take just a brief moment to sign that. Okay, I've signed off on that parenting plan, and that'll be filed with the court clerk. If any party needs a copy of it, you can certainly check with the clerk and get a copy. Does any party have any questions?
No, Your Honor.
Mr. Goebel?
No, I do not.
All right, that'll conclude the matter for today. Thank you very much.
Thank you.
Thank you.
We'll go back to the Jessica Giles and Brandon Connolly matter, 15-3-7.